Well, there has been this clamor for a new constitutional order in Kenya, and a good starting point is to ask why this clamor has been there. And in order to answer that question, one needs to look at our historical perspective as a nation. And the first point is, of course, to notice that when independence was granted in 1963, our forefathers, led by Mzee Jomo Kenyatta, came back. What people had been fighting for initially was land, and then it developed into a struggle for independence. But the issue of the Constitution, the importance of the Constitution, the ownership of the Constitution, these were absent. In fact, in terms of anecdotes, Mzee Kenyatta led the delegation from Lancaster, but the first meeting was at Shauri, and Mzee had said only him was going to address that public rally. And therefore he had the Constitution that he was waving, and he said, Uhuru, I have brought Uhuru. The point here is that the Kenyan public were given no opportunity to understand the importance of the Constitution, the difference between a Constitution and other laws enacted by Parliament. And that may be part of the reason why our leaders at that time were able to trample on the Constitution. The fact of the matter is that the Independence Constitution was a good Constitution. We inherited a parliamentary system where executive authority was in a prime minister, not in a president. Because even Britain is a parliamentary system. But of course, these things were beyond the comprehension of many people. Ideally, what should have happened is that civic education should have been undertaken, the way it's happening in Sudan when they are negotiating whether to become an independent country or not. Now, that was wholly missing in this country. And the very first amendment in 1964 was an amendment through Parliament without any referendum, without any reference to the people, where overnight the parliamentary system that was set out in the Independence Constitution was converted into a presidential system by combining head of state with head of government. I think one needs, of course, to appreciate that the issue of head of state and head of government itself is subject to, or rather its origin is in Britain's desire to continue some linkages with the former colonies. Canada, Australia, India, where it was always felt that the Queen, Her Majesty the Queen, should continue to be head of state, and therefore was represented locally by a Governor General. And South Africa, not having been a colony, having elected to go parliamentary, if you look at their system, which is purely parliamentary, you will find that although they are calling their chief executive a president, they do not have a distinction between head of state and head of government. It's a purely a parliamentary system. But anyway, in the very first amendment, we combined the functions of the head of state with the head of government, and we created a fairly powerful presidential system. The next thing is that slowly we move towards a one-party state. And although, in fact, during the first 15 years, we are de facto a one-party state, not de jure one-party state. And nevertheless, no opposition was permitted whatsoever. If one then examines the subsequent amendments, now numbering to over 40, right up to the 90s, when the clamor for a new constitutional order began, you will see that all those amendments were in the direction of subjugating all institutions that are associated with balances and checks. and concentrating powers in the institution of the presidency. You will find the judiciary, which is an important institution in terms of balances and checks. The amendments gave the president power to appoint all the 5 members of the Judicial Service Commission. The Chief Justice, who chairs the Judicial Service Commission, is a presidential appointee. The Attorney General, who is the other member, is a presidential appointee. The chair of the Public Service Commission is a presidential appointee. And when you look at Section 62 of the current Constitution, the other 2 members are judges either from the High Court or from the Court of Appeal. Now, one would have expected that, at least in respect of the judges, the Constitution would require their appointment to be by the Chief Justice. But no, Section 62 says 2 judges, either from the Court of Appeal or the High Court, appointed by the President. So all the 5 members are outrightly handpicked by the President. Now, this is a Judicial Service Commission that is supposed to be the guarantor of judicial independence, particularly in terms of identifying those to be appointed judges, either the High Court or the Court of Appeal. Now, quite clearly, manifestly, this is not an independent Judicial Service Commission, so that the judges to be appointed, in practical terms, are appointed by the President, handpicked by the President. In fact, in Kenya, to be appointed a judge, you've either got to be sponsored by the Chief Justice or the Attorney General or the Minister for Justice, or by the characters who hang around the State House and wield power peddlers around State House. And that is what has been happening. I participated in the 9th Parliament in the development of the Judicial Service Bill, whose intention was to give the judiciary financial autonomy. And I was amazed because I asked a member of the Judicial Service Commission how they go about identifying those to be appointed judges. He said, names are tabled at the meeting of the Judicial Service Commission. And I asked, how are the names generated? And he said, the Judicial Service Commission does not know how those names are generated. And I said, are the names accompanied by CVs? And he said, no, it's just names that are tabled. And our job is merely to minute. Such and such a day there was a meeting of the Judicial Service Commission, and the following names were tabled and approved by the Judicial Service Commission. He said, in the absence of CVs, in the absence of anything, isn't there a danger that one could have a typing error? And this was before the supplementary budget era. That the name of an engineer could find its way in the list, through some error or some sort, and you just approve. And he said, yes, because we don't know these people, there are no CVs, it's nothing. Which is very unsatisfactory. The point I'm making here is that the judiciary is totally subjugated to the executive. So is the civil service. As you know, the president comes and sacks all the PSs and parastatal heads and appoints his cronies and people owing allegiance to him. So the civil service, instead of enjoying security of tenure, so as to serve the Kenyan public and the government of the day, is subjugated to the presidency. So is Parliament, actually. As you know, until Parliament enacted Parliamentary Service Commission, it was relying on the executive for support staff. And most of those support staff came from the special branch, that is intelligence or prisons and that sort of thing. They were there to serve not Parliament and members of Parliament, but the executive, and to spy on members of Parliament. Now, the police, the Commissioner of Police, is headed by the handpicked individual, the provincial administration. So all the amendments were towards subjugating all institutions to the presidency. Until 1990, because that sort of system where power is concentrated in one individual, that power will be abused, it will lead to cronyism, it will lead to ethnicity, it will lead to corruption and incompetence, because people are not being appointed on the basis of ability and merit, but on the basis of their personal loyalty to the president. So the economy had been destroyed, and liberties had become impossible. In fact, I think the lowest ebb in the Kenyan society was, in my view, following the attempted coup of 1982. And that coup should be seen in context, because what happened is that with all his oppression, the first president, and corruption and land grabbing, which was there, and it started in 1963. So sorry? Jomo Kenyatta. Yeah. With all that, you can say Jomo ruled with, he had much more authority than raw power. But now with the second president, Daniel Arap Moi, taking over, I think it's fair to say that he felt insecure, and therefore he needed a lot more power, raw power. And he got frightened when the late Jaramogi and the late George Anyona, now this is about 1980, attempted to form an opposition party. They said the constitution permits multi-partyism, because the constitution had not been amended to make Kenya a de jure one-party state. It was a de facto one-party state. But Moi pushed through a constitutional amendment in 1981, which was proposed in Parliament, on the floor of Parliament, by the then Attorney General, Charles Jonjo, and seconded by who? The current president, Mwai Kibaki, making Kenya a de jure one-party state. And there were people who were detained, including the late Mukaru Ng'ang'a. For what? Because immediately this amendment went through, Mukaru Ng'ang'a, who was teaching political science at the University of Nairobi, predicted that opposition would go underground, and even a coup is likely. And of course, immediately the coup took place. They went for him and questioned him, and he was saying, look, I was merely pointing out the history. So Moi made Kenya a de jure one-party state with this, the result of this attempted coup to remove, because you were not going to remove him in any other way.
Who else was detained because of this constitutional amendment as a result?
Ironically, Raila Odinga, and it is very interesting because Raila has admitted, even in his book, that he was mainly the brainchild behind the attempted coup. But what happened is that Major General Musoba, who was a colonel at that time, was in charge of court-martialing junior officers. And I know this because I acted as counsel for the then commander of the Air Force, Major General Kariuki, Peterson Mwageru Kariuki. I acted for him in the court-martial, because he was court-martial. So I was very intricately involved. And because the court-martial is actually a very fair system of trial, much better than in a magistrate court. Why? Because the rules of the court-martial were designed that this is a trial by your equals. So you are supposed to be tried very, very fairly. And therefore the rules require you as a counsel for the accused officer to be given the entire investigation files. So I had 3, 4, 5 huge files about the coup. So I know about the origin of the coup and who was involved in that sort of thing as a result of having been furnished with all that information.
Did you also maybe, did you find out who signed the detention orders?
It was then a minister in the office of the president. I'm not sure whether it was on the tipis or something. I'm not sure who the president was. Yes, Kibaki was the vice president, the minister in charge of yes, that's right. Yeah. But the point which I wanted to make here was that what happened is that Musoba, because Raila was, and he has admitted it was his brainchild, which it was. In fact, in terms of anecdotes, he told Ochuka, after they had agreed on these, you go because we must get Jaramogi on our side. And because Jaramogi did not know that his son was involved. You go and don't mention my name as Raila. Just tell him it's your own idea, you as Ochuka. Because of course Jaramogi sometimes would be I knew this because I worked closely with Jaramogi, would be very hesitant in buying ideas directly from his son Raila. And here was Ochuka. He was a very devout Seventh Day and traveled all the way to Kisumu, where he found Jaramogi in his town house, very nice house, overlooking Lake Victoria. And he told him about the plans for the coup. And he never mentioned Raila. And Jaramogi said, deep things like this ones, you don't discuss them in town, you come to Bondo. And he was given a date, and he went to Bondo. And when he arrived in Jaramogi's Bondo home, he found Jaramogi with all the bishops of Legio Maria. And Jaramogi said, you young man, repeat what you said. And he repeated the reasons why the government had to be removed, and how it's Jaramogi they wanted to be the president to take over. And Jaramogi didn't utter a word. He merely asked the Legio Maria bishops what they thought now that they had heard. But of course they removed their holy water and the whisks, the fly whisks, blessed Ochuka and Jaramogi, and accepted the idea. The rest is history, because he then called his son Raila and was giving him money to take to the coup plotters in Nanyuki Air Base. And anyway, the rest of his history. So what I'm saying is that it is true Raila was charged with treason. But Major General Musoba, at that time he was a colonel, despite the advice from the Attorney General's office that if you want to get a conviction for treason, then you cannot afford to send all these junior officers to prison for court-martial. But Major General Musoba would not listen, and he's sentencing these colonels and these lieutenants to 20 years imprisonment, 30 years imprisonment, that's all. So by the time the treason case came up for trial, there were no witnesses to give evidence against. And that's why the treason charges were withdrawn and Raila was detained. These are things that he has admitted in his book. The point I wanted to make here was that at one level you can understand why there had to be a coup, as Dr. Nini had predicted.